This week, our guest is Gina Johnson. And Gina is the Chief Legal Officer for the Ridge Wallet LLC. Is that the right name? Did I get the name right?
That's correct.
Yeah, the Ridge Wallet is that wallet that you've probably seen sold on Amazon. It's got RFID blocking. We'll talk about that. There's intellectual property in the form of patents, design patents, trademarks involved there. And Gina is in town. We're doing this since you're in town from Chicago. We just are wrapping up our Women's IP Forum. So thank you for coming to that, number one, and thank you for agreeing to have this conversation.
Hey, always happy to be sitting up here with Eugene and Renee. It's great. This has been such a wonderful event already for all of the women, getting everyone together, meeting new people who honestly are new to the space and looking to me for advice on what to do with their brand. It's a cool position to be in because I thought when I came to Ridge and no longer had that outside counsel kind of consulting role, I would have to give that up. But quite interestingly, I don't have to.
No, you don't. And it's interesting that you point that out. There's a lot to talk about, but let's just go down this path for a minute, because there's only but so many people in the country at any given time that are like you. And people like you in different companies, you don't always want to reach out and talk to your outside counsel because the clock is ticking when that happens.
Sure.
So there is this group of in-house counsel in various industries and various spaces and across industries and spaces where you guys really do bounce ideas off of one another.
Yeah, definitely.
Did that surprise you about in-house life?
Going to Ridge, not so much. I think it's different in every in-house role, contrary to what many people think when they're not in-house, is very different, right? Mm-hmm. But the industry that I'm in, consumer goods, and especially startup brands, well, it's funny because Ridge actually was founded over 10 years ago, but we still consider ourselves to have a bit of startup mentality. And so we're much more collaborative with other small brands. I think the way that our founders view it, and certainly it's similar to the way I feel as well, you had mentors when you were starting and you can't imagine where you'd be without them. And you don't want to be the person who takes advantage of the system and then cuts the system off short, right? So we're always just kind of like, you give and you get, and we're in the giving phase currently, so it's great.
Well, that's good. And you guys have been very successful, both the company. I love the wallet. I have one. And, when you first get it, you see it, it's like, you're used to at least the guys, and I know you do more than just guys now,
sure.
But you're used to having something you fold up, and maybe when we're carrying a lot more cash around than we do, or maybe some people still do. I don't think a lot of people do. I know I don't carry almost any cash ever anymore. You used to like the bifold or the trifold wallet, and that gets really super thick, and the Ridge it's surprisingly convenient.
Yeah. I think it takes time for people to adjust to putting the wallet in their front pocket. Mm-hmm. And really that was kind of the genesis of the invention, because our founder, Daniel's father, had issues with his sciatic nerve from, in part, sitting on his bulky wallet in his back pocket. That can do a lot of damage to your back over time. And so Daniel sought out to invent something that was truly limited to the size of a credit card. You see a lot of other quote unquote minimalist brands, but you compare them to the size of a Ridge wallet and they are much thicker, much heavier. This is truly the size of a credit card. And so, yeah, I think it's innovative, and that's kind of what brought me here, because it was ahead of its time in that, if you think about it, when we started launching this product in 2014, people still carried cash. I mean, we did not have Apple Pay. We did not really have phones that we used as a form of currency, right? It was cash. Credit cards people had, mostly debit cards, but you always had cash because you always needed cash at that time. So in the beginning, it was truly difficult to get people to understand how they were supposed to both decrease the size of their wallet, but not decrease the amount of cash that they carried. And in today's world, it's almost like, we were ahead of our time because you don't need cash. This wallet is even better for you not needing cash, right?
Right. Yeah, it is. And it has, you don't think about design features necessarily for a wallet, but that one carve out at the top, which has to be used for your thumb. That's how I use it to push the cards out. Mm-hmm. Just makes it so convenient. So is that protected? I mean, I know you have design patents, but you know you have utility patents. But what is actually protected?
Yeah, that's a good question. So our foundational patent was filed back in 2017, but dates back, I think, to mid 2016 is our priority date. That patent covers the internal features of the way that the money clip engages with the inside of the wallet. Because we initially actually launched a wallet on Kickstarter that had a spring mechanism, and a lot of our consumers were saying like, okay, this is great, except for the money clip keeps falling off because it's just an external spring mechanism. So our founder had to create a way to make sure that the wallet still maintained its very small size, yet was able to include a money clip that wasn't falling off all the time. So that foundational patent, we call it the 808 patent, that really covers the way that the money clip engages internally. From there, we have use that filing date as the basis for a lot of our other patents, both design patents and utility patents. We have a cash strap mechanism, which is covered by a similar utility patent governing the way that the cash strap engages internally as well. Most of our utility patents have to do with the internal engagement of either the cash strap or the money clip. And then our design patents really cover the exterior look and feel of the product, which is so important because, as you know, we've been discussing at this conference today, there's a lot for us to do in the brand enforcement world. And the best way that we found for us to do that is to create this kind of bulletproof scheme of intellectual property that covers us in all facets and is easy for a marketplace like Amazon, Alibaba, eBay to consume so that we can use it on our behalf.
Yeah. So I'm going to keep going down this path, but I'm going to make a mental note that I want to talk to you also, because we just jumped right in and I love it.
Yes.
But I want to also talk to you at some point here before we part ways in this conversation with how you actually got involved in this company. But since you brought up the online marketplaces and that sort of thing, and that was one of the things you were here to talk about at the Women's IP Forum on a panel with others like you. Which form of IP do you find most useful to stop the counterfeits, dupes, and fakes? And maybe what we should even do is, before we answer that part, to you, what is a counterfeit, what is a dupe, what is a fake? Are they all synonyms or are they slightly different?
They're slightly different, for sure. So, okay, so what was the first one you said?
So well, no, take it like what are the differences in your mind between counterfeits, dupes, and fakes?
Sure. So I would say dupes and fakes are pretty similar to me. A dupe is really just trying to look and feel like Ridge without using the brand name, right? So a dupe is a product that is probably being sold as a competitive product, trading on the minimalist wallet space, and trying to induce confusion that it is either Ridge or very similar to Ridge without using the brand name. A dupe can, but does not have to, use other forms of our intellectual property. So a dupe can infringe or it may not infringe. And the reason that I say that is because I think that's an important category as well. So I would almost say like we look at it as infringers, counterfeiters, and then dupes or fakes. So let's start with infringers.
Well, before you go there,
sure.
Is a dupe / fake, whatever you want to call it, is that what, you know, when I was coming up in the industry, we would call a knockoff, or knockoff's yet a different category?
I think that it's pretty similar to a knockoff. It just depends on whether you think a knockoff has to infringe intellectual property, right? And right. I don't think so. I think a knockoff, again, is just trading off of something, whether it's protected or not, that is causing consumers to be confused as to the origin of the good.
Right. I would agree with that. Okay, good. So we're all on sort of the same page with our lingo here, which is always the first step.
So funny.
Okay, so now you were going to tell us about counterfeits, I think.
Yeah, so counterfeits to me they're trying to pass as exactly a Ridge wallet. They want people to believe that they are buying the real thing for a lower price. And so this oftentimes can be a leaked manufacturer, right? Or stolen shipments that are being sold as counterfeit products. Sometimes they are, let me rephrase this. I'm going to start over.
Okay.
Okay, so a counterfeit product to me is a product that is using the brand name and really trying to get consumers to believe that it is a Ridge product, right? And so it would be using the Ridge trademark, for example. It would be somebody who, let's say in China, we have our manufacturers running the line late at night, making Ridge products, selling them on Alibaba as Ridge products, but not by the authorized seller Ridge, by some third-party shop. You can get this Ridge wallet for $14.99, and it looks exactly like the Ridge wallet. It has the branding. No, that's not a Ridge wallet.
Right. Well, is it or isn't it? I mean, because one thing that I asked that is like once upon a time, when I was practicing at the earlier part of my career, we had an attorney at the firm who was doing this same sort of stuff, and they found out that the counterfeits that they were dealing with weren't actually counterfeits. What they were was their own product. So the person in this, and I want to say the factory was either in India or Bangladesh or something like that, and was supposed to be running 2 shifts. And the manager of the factory started running a 3rd shift. And so the way that they discovered this was the company's like, well, we got to figure out not only what they're doing, but we got to figure out where they're sourcing their materials and how they're making it. Because if they can make money on how much they're selling it for, we need to rethink our manufacturing. And it turned out that it was so cheap because they were just stealing the molds, they stole the materials, and it was running in their same factory, just the 3rd shift. And the employees didn't even know. The employees thought they were employed by the brand.
Oh, yeah.
You know, so has anything like that crazy ever happened to you, or is it really just somebody doing their own thing, inferior products, and stamping your trademark on it?
You know, that's a good question. We are in the process of looking into a shipment that came in through TikTok Shop, where it looks a lot like what was being made in the early days at Ridge, but we've stopped making that, and we thought we had all of our shipments accounted for, so it's very likely to be either a former manufacturer or a true counterfeit. So that will be revealed soon here, and then when that is revealed, we'll take the appropriate legal action depending on what the case is. So
there's like a little bit of detective work involved. Do you find that exciting? Well, 1, do you agree? And 2, do you find that exciting?
I love it. It's funny because when I started at Ridge, I actually used to have my sister buy products for me. Because, you know, obviously if it's coming from Gina Johnson, or even if I put like my daughter's name, whatever I did, I was worried that it would come back to me. So I would just ask my sister, can you just buy this product, you know, put it on my credit card? We want to examine it to see if it's a counterfeit, where it's coming from. I want to see what the shipping label looks like when we receive it. So she would buy it. And then we started getting into litigation, and I was like, wait a second. I love my sister, but she's not going to be a pro witness for me here. So we started using a private investigator who does this. He makes sure that like chain of custody and everything is preserved very well. And so we've kind of upped our game in that regard. But I think it's fair game. And you want to know why? Because unfortunately, a lot of these entities abroad will lie straight to your face about the origin. And so you need to do some undercover work in order to get the truth. Right.
That's just the unfortunate reality. It's in addition to the people who are just going to lie straight to your face, there's the whack-a-mole nature, the people who you maybe never interact with. They're not lying, but they pop up here, they sell a few hundred, a few thousand, 10,000, whatever it may be. They shut down, then they move to an adjacent company and with a similar name and do the same thing all over again. And it's rinse, repeat, rinse, repeat. How do you deal with that?
Oh, we've done it all. I would say you really have to think about what your goal is. And for Ridge, our goal is to just get rid of this mass confusion about what is a Ridge wallet and what isn't. A Ridge wallet is a wallet sold by the Ridge Wallet LLC. It is not anything else other than that, okay? And yet, I think I said this in the panel earlier, people now refer to anything that has the same silhouette as our product as a Ridge wallet. You can go on Reddit, you can go on X, TikTok, everywhere people are saying, I got my Ridge wallet. And I just want to shake them and say, does it have the Ridge logo on it? Right. If not, it's not a Ridge wallet.
Well, that's
right?
Your trampoline, kerosene, elevator moment, right? I mean,
right.
You know, all those things used to be trademarked.
Right.
So how do you functionally in 2025 fight Ridge from becoming generic? Which I don't think it has.
Right.
But it's got to be something you think about.
Yes, definitely. I think that's in part how I got my job here, which we can talk about as you noted. But really, we wanted to go big at first. So back when I was at K&L Gates, we proposed to Ridge, let's just go to the ITC. Let's try to cut this off at the source, right? And see if we can do that, and then use that general exclusion order to our advantage. And that's what we did. I came in-house in the middle of our ITC case, finished the ITC case as the chief legal officer of Ridge, got the GEO, and we use that on most marketplaces. Amazon's great once you have an order. Alibaba is pretty good with the order. The problem is a general exclusion order only excludes products that are imported into the United States. And oftentimes, some marketplaces will say, well, this product is being sold on Alibaba. You need to buy the product so that you have proof of importation. Short of that, we can't use this GEO. And it's like, come on, guys. Like, I'm in the U.S. This is being advertised and marketed and offered for sale to me in the U.S. I cannot practically order every single infringer off of Alibaba or AliExpress. Ridge will go broke if that's the case. Not really, but I mean, it's just such a waste of our resources. Right. We shouldn't have to do that. And most of these, you have to order like minimum quantities of like 50 or 100. I'm not doing that. I'm not waiting for them to come to the US. That's not, that can't be how we take these things down. So the GEO is limited in how effective it is on online marketplaces. So then what do? This is where just building a robust patent portfolio, IP portfolio, is so important. So I talked a bit about our foundational patent, the 808 patent, which was a utility patent. That's the patent we took to the International Trade Commission. From there, Ben Weed came in-house. He had a background in patent prosecution, became a patent litigator, but was able to do all of the patent prosecution for us in-house. And we just got creative with our patent prosecution strategy. If you look at the wallet, we got the silhouette of the wallet in a design patent. So that's great because that can pretty much eliminate all of the just knockoffs who keep the shape but aren't necessarily counterfeiters or using our trademarks, right? They just have the silhouette. They want to induce that confusion. They're now infringing that design patent because it is for the silhouette of the product. But then you have people who are getting a little bit funnier with it all, who are eliminating the money clip because in that design patent I'm talking about, the money clip is required. So now they just take photos of their product without the money clip on it, and they say the money clip can be sold separately, optionally, or they'll take out on Alibaba, they'll take out the finger notch, the thumb notch that we discussed, and they'll show a little carving of like what they could do to the product if you want that thumb notch. So then you have to get even more creative. And we looked at and filed for patents that show the end view of the wallet. And if you look at that, there's certain ways that the money clip engages from a design perspective. There has to be two holes on either side of that money clip for the money clip to go inside. So we claimed literally just those two holes from the end view. So we've gotten so creative with the design patent portfolio. We use those things. So that's kind of the design patent utility patent side. In addition, we did file for a 3D trademark, which covers the beveled edge of the wallet because we noticed that there were some marketing pieces from other brands that would intentionally say, ours is just as good as a Ridge wallet because Ridge uses beveled edges, now we do too. And it's like, okay, you're purposely trying to induce consumers to believing this is just as good as Ridge, it has the same shape, and now it has the beveled edge. Well, guess what? We have trademark coverage over that now as well. So that's been great. But what do you do if the marketplaces still aren't accepting some of these things? And inevitably that will happen because they don't want to be the arbiters of infringement, validity, those types of things. What do? You bring them an order. I talked about the ITC order, but we also live in the Northern District of Illinois. I'm in Chicago. What other types of orders can you bring to Amazon so that you don't have to make them do this gigantic job of trying to figure out whether there's infringement? we file Schedule A cases, or we'll file against a foreign defendant that's unlikely to show up, get a default judgment, and take that piece of paper to Amazon. So it has been a journey, Gene, and we've gone through just about everything you can do. And if you ask me, are they still getting away with this? Yeah, they still are, and I am constantly trying to figure out new ways to combat this.
Yeah. This is an area where once you're employed in this area, it's forever. I mean, and because the problem only grows.
That's right.
Because for a variety of reasons, not the least of which is there's real money to be made stealing somebody else's intellectual property in the form of dupes, knockoffs, counterfeits, whatever you're doing, and the penalties are so low.
That's right.
I mean, even if you get caught. And yes, there are criminal provisions, but they're very weak. I mean, a lot of people don't like to believe this, but there's multinational criminal organizations involved in counterfeiting. Maybe not the Ridge wallet, but across the board, generally speaking, because there's so much money involved. The margins are better than drugs. And if you get caught, you don't have to worry about going to jail for 30 or 40 years, and the people aren't shooting at you. There's not quite the gang involvement. It's a different level of organized crime that gets involved in this. So it's only going to be a problem that continues to grow. And it's frustrating. But before we go too much further past it, can you tell the audience, what is a Schedule A case?
Sure. So in the Northern District of Illinois, some judges have permitted plaintiffs to file these massive cases naming 100 or more defendants under seal, so that even the defendants themselves don't know that they're named in the case. And the reason would be based on either trademark infringement, design patent infringement, and you file these cases naming all these defendants, again, under seal, then you get the judge to issue an order seizing their assets, or freezing their assets, and then you can basically negotiate and settle with them once the assets are frozen. And this is foreign defendants who you have venue over anywhere in the United States. The Northern District of Illinois has shown a tendency to accept these types of cases, and they're unlikely to show up. And so it really takes their assets being frozen for them to come to the table, because short of that, they know that a piece of paper saying they owe you this much in damages is pretty much worthless.
So because this whole Schedule A stuff, probably for the people who aren't involved in this part of the intellectual property world, they look at that and say, well, there's no due process there. And maybe there's an argument to be made there, I suppose. But this is not something where, this is not a loophole you can drive a truck through, right? I mean, this is not where you just all of a sudden in Chicago, you can sue people without them knowing about it and freeze their bank accounts, right?
No.
There's a level of proof that is required. So what is the level, what do you show up with at the district court to get them to realize, okay, no, this is a bad actor. They're unlikely to show up. They're just knowingly and intentionally causing harm to an American company and American consumers.
Yeah. So you have to purchase the product. You have to show the infringement, right? Which would be, in our case, we just initially started taking down people who were using Ridge in their product descriptions or on their products. And so you purchase the product, you show the listing, and you show the marketplace on which the product's being sold. You do some digging into where the name of the company is selling, whether they have a large presence on the marketplace, what else they're selling. You want to make the freezing of the assets as narrow to the infringement as possible. I think that's the other thing. Sometimes this goes a little bit too broadly, and that's another issue that judges have with due process, because if you're freezing an entire account for a marketplace that sells just one wallet that infringes upon my intellectual property, but otherwise is grabbing, or they're selling a bunch of other things, there can be an issue with that. But you show up with that evidence, and then you have to do your motion for alternative service, right? You have to demonstrate at some point later that they become aware that this lawsuit, after the assets are frozen, that this lawsuit is on their radar, right? So that's important as well. And then you just negotiate with them from there, because it's almost like you have no negotiation tactic short of their assets being frozen because you just can't convince them that they should respect the United States intellectual property system until you have something to trade off with, right?
Well, and you have to freeze their assets too, right? Because these are people that exist in probably mostly China, but not exclusively China.
Yep.
They're never going to set foot in the U.S. The only assets they have in the U.S. are electronic digits in a bank account, right? And the minute you sue them, they're going to drain the bank account. So they're judgment proof. And we've seen this over and over again. You know, rinse, repeat, rinse, repeat, rinse, repeat. And that's got to be why the judges in Chicago have probably just had enough of this. Is that fair to?
Yeah, I think so. I think it goes two ways, because we are seeing some judges who are more hesitant to go through with these, and they'll actually say, like, I'm not going to do this. You have to get rid of some of these defendants. I'm not handling 100 defendants in one case. So it's annoying, because then you essentially you dismiss the majority of the defendants and refile and just try and get a different judge who believes that this is
a problem.
Yeah. So it's annoying, but.
So no, I get, like, in the patent world where you don't want to have 100 people, because the facts are going to be different, right? In a lot of situations, the facts here are the same. They're knocking you off. They're in some remote country. They're never going to be coming to America. They're doing real harm. And and by the way, once you get them to stop doing this, they're just going to pop up with some other different entity at some nearby address in China where they're already at, and it's going to be over and over and over again, right? You know, because. And that has frustrated me, not only in this space but across the law. It seems like the property owners in a lot of different areas of the law are the ones who are burdened with the ball and chain of due process, and those people who are intentional criminals. This is not, oh, I'm sorry, I didn't know that was yours, or a legitimate dispute where I didn't think I was infringing. These people are organized crime, for crying out loud. But the law often inures to their benefit and favor, and just lets them continue on with these criminal enterprises. So the Schedule A is important. If you don't know about it and you're in the retail space like this, and you have problems with hundreds or thousands of these nefarious actors, that's a big tool.
It really is. And I mean, you hit the nail on the head too. Like, if we don't freeze their assets, they're just going to drain their bank accounts and go somewhere else, because guess what? They have no respect for the legal system here. So they're already inherently not looking to comply with what's coming next. So you need a bargaining position to start from, and that is with the frozen assets.
And that's hardly should be shocking to no one, right? They're criminals, right? Of course they're going to have no care about what the law says, because if they did, they wouldn't have been criminals.
Yeah, and I guess this isn't great either, but the reality of the situation is, how do these end up? Okay, you settle with them, you take some of their money, you release the other part of their frozen assets, and you get them to sign a settlement agreement. And then you're basically, making a deal with a criminal, to your point, and you expect them to follow this settlement agreement and not just pop up under another name. It's hard to track who pops up under another name still. So you're not ever going to be done with these people. They know what they're doing, and they're going to continue doing it. But it's almost like, can you just induce enough pain, and just kind of poke them enough times to make them consider maybe just switching from selling wallets that look like Ridge wallets. Go sell something else.
Well, right. I mean, because if you're going to give them that kind of grief and adjective, just go knock off counterfeit somebody who isn't.
I mean, and that's
because
truly,
sadly there are trademark owners, patent owners, design patent owners that don't enforce. They don't enforce nearly as much as you guys. Maybe they don't enforce at all, that's a bad fact for them. But you want to make your house the safest on the block, right? It doesn't need to be Fort Knox.
Yeah. I mean, that's truly part of the strategy. And I kind of wish that I thought about that sooner, or thought about saying it that way. But really, the reality is, just make it look like you're going to bury them, and they'll give up because someone else isn't going to give the same
it's gonna be
level
easier.
of effort. And I think that's another thing. Sometimes I have brand like CEOs or chief marketing officers, founders come to me and say, oh man, you know, what you guys are doing with your legal in-house, I want to do that too. Is it worth it? And I'm like, well, let's think about what your goals are. If you have this many knockoffs, infringers, counterfeiters, dupes, whatever you want to call it, then maybe it is important for you to get in-house counsel so that you're not paying by the hour for somebody to do this, because if you want to act tough, it takes time, and that translates to billable hours, right? So for Ridge, it made sense. And it's so easy for me now, in a sense, to look tough, act tough to these infringers, because I know everything about our IP. I know where we're going with our IP. I know where all of the marketplaces are, where we're finding success and takedowns on the marketplaces. So it really does make sense, but you have to dedicate the resources to it.
Yeah. Yeah, and you know, just to cascade for a minute, I don't practice currently. I focus on IPWatchdog, but when I was practicing, one of the things that I did, so far, knock on wood, I've had 100% success rate, is dealing with copyright trolls. And it's usually, I've done it pro bono usually, because these copyright trolls are just like these counterfeit. I mean, these are people who are just trying to scam folks out of money. And I just started taking, you know, you push back, and they push back, and they're convinced you're going to cave. And then finally I can get them to realize, no, I'm not going to cave. We're not going to cave. We're not. And I've told one of them, the last one I had to deal with, I said, and if you continue to be a real jerk here, my client's going to own your client's portfolio, right? Because this is just egregious, you know.
Right.
And then they laugh. They don't think you're serious. And then I say to them, it's like, look, you're never going to get a dime. I understand what your business model is. You've already lost money dealing with me, because we're fighting over. Sometimes they'll settle for a few $1,000s, right? And I'm doing it pro bono. I'm like, and I let them know I'm doing it for free, and I will do this for as long as I need to do it for free. And that's not your model. Your model is to scam a lot of people out of a little bit of money, and you've already spent more time dealing with me than even if we tomorrow pay you,
Right.
which we're not.
Right.
So go away, leave us alone. And finally, when you get to that point, the copyright trolls, they do. And so how does that apply? I think that's what owners, particularly small business owners that have a lot of infringement, you need to have a reputation that we're not playing around.
Right.
We're going to come after you, and we're going to stop you.
Right, but you have to show that you're willing to take that step too.
Yes.
Like, there is a certain level of
commitment.
Right. I mean, and we've filed multiple district court actions. We obviously got the GEO at the ITC, which was no small feat. And, you know, having former patent litigation counsel in-house helps as well, because it's not like I'm just like, not just, but it's not as though I am a corporate person coming in-house and saying, we're going to sue you with our IP, and then, like, I have no idea how to do that, right?
Well, that's a good segue into how you got involved. I mean, because you were a roll up your sleeves, I'm going to sue you, or I'm going to defend my client in the patent infringement world. You were a real bona fide patent litigator, right?
I like to think so.
Yeah. So how did you go straight from law school into patent litigation, or what was your trajectory into litigation, generally speaking?
Yes. So I got my job at K&L Gates through on-campus interviews at the University of Illinois College of Law. I originally thought I would just be a generalist in the general litigation group at K&L Gates, but as a summer associate, my writing skills were always some of my strongest skills, and the patent group was looking for somebody to put a lot of their technological jargon into terms that would be understood by the ultimate consumer of this writing, which would be either a judge, who is not always technical, or a jury, also very seldom having technical people. So I started working with the patent litigation team basically to dumb down what they were saying, because you're not going to be successful if you're not catering to your audience, right? And I just loved working with that group. We all got along really well. I found it very interesting that, unlike many other areas of law, I was able to practice across so many different types of technology. The first case that I went to trial on was recombinant factor VIII blood clotting technology. And then the next case I was on was positive train control. So it never got boring, and I absolutely loved it for that reason. So I was at K&L Gates for about 8 years. I became partner in the patent litigation group. I never thought I was going to leave. Honestly, I loved what I did. I had 2 kids. I came back from a maternity leave to go to trial against Apple in the Western District of Texas. We settled that pretty much the Friday before we were supposed to go to trial. We had always had Ridge Wallet as a client, and by we, I mean the firm. We did a lot of their corporate work. I think we formed their LLC, and so they never thought of Ridge as they never thought of K&L Gates as anything other than like their corporate shop. So they had different IP counsel at the time, and ultimately they lost their foundational patent in the district court with different IP counsel. And so they were looking to shop around for the appeal. And our corporate counsel at K&L Gates said, hey, I know these 2 great patent litigators, Ben Weed and Gina Johnson. They'd like to pitch the case to handle the appeal. We got the work. We took the case to the federal circuit, and we got their patent back. So I think at that point they realized we knew what we were doing, and they trusted us. We had insight into some of their financials and information that, you get insight into when they're a client of yours. So they said, do you think it makes sense for us to hire you guys in-house, knowing what you know? And I was like, us? No, we're patent litigators. Why would we go in-house? And they're like, well, we would just pretty much let you do the same thing you're doing now at K&L Gates, except only for us. And I had to sit down and really think about it, because I always envisioned my life as like a law firm partner. Bill my hours. I thought I was really good at making relationships and getting new clients. I loved what I did, and I was scared to give it up. But the Ridge opportunity was truly just a unicorn of an opportunity. There were certain upsides to taking the job, including with 2 little kids, being able to work in a fully remote environment. I pick up my kids from school at 3 o'clock, and I don't have to worry about billing hours for the rest of the day if my work is done. But more so, it is opening my eyes to everything that I should have known as outside counsel, because now as in-house counsel, I understand what would have made me even better at the outside counsel role, right? Like just anticipating and understanding the needs of your client in-house. And now I see all of that from the inside, and I feel like this has really just kind of evened me out in a way where from here I could do anything, because I have both perspectives and I can use both of those perspectives going forward.
Yeah. I mean, that's a great story, and that is not an uncommon story where you have counsel with a growing company, and they get to the point where it's like, well, why don't we just have you come and work for us all the time? And it winds up being good for everybody. I'm glad it was good for you. And Ben has, and that's how I met you, was through Ben.
Yep.
And because Ben has been on our stage on a number of times, and I know he's been involved in at least one of the podcasts. With one of his panels, I turned into a podcast, and he's always has great stories, as do you, about what's going on with the infringers and that sort of thing. I want to come back to the IP. Which form? Because I'm not sure we went all the way down that thread, and if we did, forgive me. But which one of the IP rights? Like, if I told you could only have one of them, which one is the most valuable to you today? Is it the trademark portfolio, is it your utility patents, or is it your design patents?
Given where we are today, and that we don't see many true counterfeiters, just people knocking off the silhouette of the product and attempting to sell and induce confusion based on what the product looks like and not by putting our brand on it, I would say our design patents that cover the silhouette are probably the most important to us right now, because from my perspective, our goal is to just get rid of infringers of that technology that try to use the silhouette to confuse people and undermine the price at which we sell our product. So definitely from my perspective, it would be that silhouette design patent. I think it's a hard question to answer though, because it just depends on what the goal is. I think another way to look at it is like the 808 patent was our foundational patent, and it allowed us a lot of opportunities given the earlier filing date. So maybe that's the most important one, right?
Yeah, and that's why I asked today, because I think it does shift over time and depends upon the facts on the ground. I mean, because I do think you need all of them. You need a utility, and certainly if you're selling anything that's tangible, you have to have designs. It's always struck me as really odd that more people don't have design patents, because they're not that expensive to get. There are no maintenance fees on design patents. They last for 15 years now. And they are extremely powerful for stopping those people who are trying to steal your market, to look like you, to create that confusion. Now, I understand that's not maybe for some companies the biggest part of what is their problem, but for the amount of money that gets invested to get designs and the fact that you don't ever have to pay for them again once you have them, I think it's a great deal. And I know that, for example, in Las Vegas, where they have a lot of trade shows, they have a special window at the district court there, I'm told, where you can go up and you get a TRO with a design patent. You say, okay, here's a picture of what's being shown in the convention exhibit hall. Here's my design patent, and the judges will instantly give you a TRO, which you can't get with really any other form of intellectual property. And if you get a TRO, it doesn't matter whether you get a permanent injunction or whether you win the case ultimately. What you want is to stop them from taking orders at that show this week.
Yeah, exactly.
And the TRO is good for like 10 days, right? I mean, so it's about strategy. And that's the thing that, and I know Ben has told the story when he's been here about how getting people off of, for example, Amazon at a certain time of the year can be worth $250,000 or more to the company.
Yeah, but you have to anticipate that. And I think that's the thing, right? We're not just looking at what's going on right now. If we were, then yes, all I would need is this one design patent. I have to prepare for a day where we have a bunch of counterfeiters trying to use the Ridge name on products. And then if I am not prepared for that, it would take a year for me to get a trademark if I file then, right? So I have to be thinking worst case scenario in the sense of what are the possible ways that people could induce confusion, and how do I get out ahead of that? So yeah, our trademarks we do a great job filing trademarks as well across all of our categories of products that we sell, and then we try to anticipate the product categories we're going into in the future, within a year, obviously, that you have to file a statement of use within a certain period of time for trademarks. So that's the limiting factor. But they can become, or maybe are, equally as important, because think about if we didn't have trademarks and somebody could put Ridge on a wallet. Now, what does my silhouette patent do for me? Not as much, right? Right? So it's just so important to protect everything.
Yeah, I know. And it was unfair for me to say if you only got one, because I don't think you can have just one. But I wanted to see, like, at the moment what your thoughts were. Because they're like three legs to a stool. If you're selling something tangible, your trademark portfolio, design patents, utility patent, and you take one of the legs away and the stool falls over.
Yep.
It really causes a problem with the strategy. Now, in the time we have remaining, and this has just been fascinating. I mean, time is flying by. This is a great conversation. Thank you. But one of the things that you were specifically here to talk about was on a panel with Jane Durden from Amazon. And I know you've had some, I wouldn't say issues with Amazon, but Amazon has a different process that if you're unfamiliar with their process, you could actually do something quite detrimental to your desire to get infringers, counterfeiters off of the Amazon platform. Can you tell us about that?
Sure. Yes. So back when I was at K&L Gates, I wasn't doing any Amazon takedown work. I was just a patent litigator. So Ridge came to us. They explained to us what their issues were with a lot of infringers on various marketplaces. They asked us to put together a strategy. So we put together a strategy which involved in part this ITC filing and then also in part a filing in the district court against one of our bigger competitors at the time, who was truly just like stealing market share off of Amazon. If you looked on Amazon at the time, based on where the price points were between those, our brand and this brand, they had figured out how to price their products pretty close to ours, but not as high as ours, use our technology, and they were making a good amount of money. So they were our biggest threat. So we filed this district court litigation against them. And then I go to Amazon because we're getting more patents issued and I'm feeling more confident about, our portfolio. And so I go to Amazon with these patents that we're using in the litigation as well. And I'm like, hey, here's our patents. We have an apex for one of them, which means a utility patent. We went through the process of getting a neutral evaluator to deem that this product was infringing. So can we use this and get them taken down? And then, we'll see how the court stuff shakes out. Maybe we'll get some money from them in the court because we're suing them for past damages. And Amazon's like, no. You don't get to take them down when you're in active litigation. And I was like, what? What do you mean? And they're like, well, we have this policy that once you file a litigation, we let the court handle it, so we're not going to be the arbiter of whether or not they're infringing. And I was like, where is that policy? Can you tell me about it? I was obviously very frustrated, but if I missed the policy somewhere, I was going to take accountability for that. And they're like, well, it's not like a written policy. It's just what we advise internally.
Just what we do.
Right. It's just how we do things. And that was back in 2022, maybe 2023. This is now a known thing, I'd like to say, although I don't think it's still written, but we do hear people from Amazon coming out and speaking about this.
Right.
And I think it's so important for anybody, whether outside counsel devising a strategy for a client to take down competitors, whether in-house counsel who's the one who's determining whether to file a lawsuit or just do like Amazon marketplace takedowns. I think it's important for Amazon to let people know this because it ultimately will put people in the position of making a decision, which is good for Amazon and good for the brands as well, right? So that was one, I would say, setback in our assertion that was totally unexpected. And that was so frustrating because once the litigation was pending and we were beyond the answer phase at this point, so it's not like we could just drop it. In fact, there were counterclaims filed against us. So even if we wanted to settle out our case, they could have just kept the case going on with their fake counterclaims just so that we couldn't take them down on Amazon.
Yeah, I always want to make sure attorneys hear this, right? Because it seems counterintuitive to me that you mean since I sued them because I believe my case is strong enough and they've caused injury to me that I want damages for, you won't do anything. But if I didn't sue them, you would do something. And that just seems odd, and it is what it is, I guess, right? Because for better or for worse, Amazon's the big dog in the room, right? That's the big platform. They have market-moving capability because everybody wants to sell on Amazon, and for a reason. They've built a tremendous platform over the years.
Yeah, I agree. That was my view at the time, 100%. I couldn't see anything.
Do you see their point of view now?
I do. I think I understand that bringing them in order puts them in a much better position than asking them to determine whether there's infringement. But, okay, let's say they make known publicly that filing a litigation precludes you from using their Apex or brand registry system for any of the patents in that litigation.
So, and let me just tell you, is this called colloquially the Amazon court, or is that different?
So brand registry is the Amazon platform through which you can assert your intellectual property, which it would be utility patents, trademarks, and design patents. If you have a utility patent in the, Amazon court you're referring to, you would go through what's called the Apex procedure because their theory is we don't in-house at Amazon. I believe this is their theory. To be clear, I can't speak on behalf of Amazon, but I think that their theory is we don't have people in-house with specialized knowledge to determine whether a utility patent is infringed. There are claims that need to be construed, and So we're going to hire a neutral evaluator. So as the brand, I put forward, I want to say $2,000 or $3,000 that goes to a neutral evaluator, and he or she assesses our claim of infringement. The other side has an opportunity to respond either with an invalidity case or a non-infringement case, and this neutral evaluator makes the decision. If we win, we get our money back, and the other side does not get money back. So that's what we did with some of our intellectual property, our utility patents. That's through the Apex process. Regardless of whether you're doing an Apex proceeding or a design patent takedown, if any patent that is related to one of the patents you're trying to assert on Apex or brand registry is tied up in litigation, Amazon puts up its hands and says, we don't want to be involved. Let's let that district court litigation play out. I used to be so frustrated by that for the same reason that you've articulated. I am actually filing a case under Rule 11 as an attorney that I believe there is infringement, and that's what's precluding me from being able to use your system. I couldn't stand that. But at the same time, I understand their concern of inconsistent results. How would it look if Amazon takes that down and then the district court plays out and there's a finding of non-infringement? They're concerned then, I think, that they would be liable for some reason for the inconsistency. So I do understand it from that perspective. What I think is kind of worst case scenario, though, from a brand perspective, is you hold off on filing your litigation because you believe Amazon will do something. You assert your intellectual property on Amazon, and then they refuse to take down. Now you're in a bad position because you've delayed your district court litigation pending what happened on Amazon. They're refusing to take down, and now it's almost like litigation is a secondary strategy, which is kind of not the best for the brand because litigation takes a very long time, right?
Right. How long does it take to work its way through the Amazon process?
It depends. The Apex procedure is longer. I want to say it takes about a month because you make your case, then there's time for the opponent to respond, and then there's time for the neutral evaluator to make a decision. Brand registry, when you're using a design patent or a trademark, you can find out within an hour. You can find out within a week.
So it's not so bad to wait. I mean, and you probably should wait, right? If your goal is to get something off of Amazon so you are not damaged. Let's say it's, December 5th and there are infringers on there, counterfeits, knockoffs on there. You want them off because now it's like everybody's rushing for last minute Christmas gifts.
Right.
You're not going to get a TRO. Like we were talking about, you get the TRO in Vegas for conventions. You don't get them for infringement from somebody overseas who's selling during the holiday season. That's not how it works.
Yes, but let's say that your initial complaint on Amazon is rejected and you find out a week later that it's rejected. Then you can escalate the complaint and try to recraft your argument. That takes time too. So there's a lot of uncertainty with Amazon as to, how long it's going to take for them to come back to you. What I will say, and, I've met some people internal to Amazon. Jane was phenomenal and is phenomenal.
Yeah, she's great.
They really are trying their best. Yeah. They're in an impossible situation as well. You just see it from the perspective that you're sitting in at the time of the assertion, right? So it's like, Amazon, aren't I the only one who needs this help? Why are you not addressing me immediately? And it's
I think we had that conversation about when you were a patent defending accused infringers.
Yes.
You see that world and you're like, patent owners, they're all abusive because you've been dealing with some that were. Mm-hmm. And then you go and you work in-house for a patent owner, you say, whoa, wait a minute, not all patent owners are bad.
Right.
It's always from your perspective, your viewpoint.
For sure.
And that's why I think we need to have a conversation. We need to talk. We need to get everybody in the room and talk, because I do think everybody's got a point of view. Everybody sees. So what are the problems? That's why I always try and have that conversation, because if we're not talking about stuff, we're never going to understand your viewpoint, which is different than mine, or maybe slightly different, or maybe vastly different.
Yeah.
And when you understand, if even if you can't agree and you still disagree, it does allow you to craft a better strategy.
Well, and that's the thing. It's like when I spoke with the woman from Amazon back in 2023, and I let her know how detrimental the fact that this like made up rule about not being able to file litigation was to our strategy, she was kind of like appalled that this would be the case. She was like, "What?" And I'm like, "Well, we made our decision not knowing the rule, and so it did inform our strategy. It would have informed our strategy had we known." And she was like, "Oh, I didn't think about it that way."
So maybe that's why, because since then, Amazon has been more forthcoming about their internal policy. So maybe you guys did change.
I like to think that I did, honestly, because it was a great phone call. I think being a patent litigator at a pretty reputable firm prior to this also gave me like a leg up in that conversation. I wasn't the brand owner with no knowledge of the way that intellectual property works, just trying to talk to someone really high up. Right. So we just had like a very frank conversation. And honestly, I just remember I kept saying this. I kept saying, let me help you. I'm not just here to help me. I'm not just here to ask you to help me. Let me help you, because I feel like I could make your world a lot less confusing if you just let me spew to you like what brand owners are feeling at this point, so that you can see why they're so frustrated and why these things get escalated and heated so quickly, because you just need to hear this perspective from somebody who's so new to this perspective and like just came from the world of IP litigation. I think it was like the perfect kind of clashing of all of our like backgrounds and thought processes. So it was a great conversation.
Well, that's good. That's good. See what you can accomplish when people actually talk.
That's right.
Yeah.
That's right.
So, well, this was fascinating. I really appreciate you being here. Before I let you go, is there any parting thoughts of words of wisdom to others in the audience, whether they're attorneys or brand owners at similar companies?
Yeah, definitely. I feel like this is so basic, but I cannot say this enough. I was just at a conference called Beanstalk in New York, where all of the founders of startups gathered, and they all could not fathom that they should spend money and invest in intellectual property before they knew whether they were going to have successful products. They can't figure out how that could be worthwhile because it can be expensive, at least to a small startup brand without a ton of disposable money, right? And all I can say is that you will never regret filing for even a provisional, right? Giving yourself some time to figure out what you want to do. You will only regret not doing it. And so I think biggest piece of advice is just file something so that you get that filing date early on before you make your own product, prior art, or whatever you do. Just file something. Talk to somebody who knows what they're doing. Yeah. Don't get advice from your brother's friend's brother who does patent work on the side. Sit down for an hour even with a reputable IP attorney. Get their advice. File something, and then you will never have any regrets.
Yeah, that's great advice. You know, and I used to give that advice a lot more, and I've kind of gotten away from that. Maybe I need to resurrect some of those old articles and update them a bit and pound that drum, because by the time you know you needed it, it's too late to apply for it.
Exactly.
And so you have to do something. And you obviously have to be smart about it because it can be expensive. But there are creative ways that you can get some meaningful protection without breaking the bank. And that's a great way to end. I really appreciate you being here, Gina. Thank you.
Thank you so much for having me.